Ladies and gentlemen, as Judge Gibbs told you, my name is Kevin Dutton. I am the elected district attorney for the 1st Judicial District of the state of Texas. That covers Sabine and St. Augustine County. I'm not going to take a lot of time. One of the things that I went ahead and did is I went over all the rules for the debate and the timing with the candidates prior to us coming in here. So that's something that's already taken place. I'm not going to bore y'all with all the details that we're going to go through. Everybody asked me, why are you doing this? This isn't even your county. And I'll tell you, it's beat into you as a lawyer. If a district judge calls you and says, will you do me a favor? you pretty much do that. Even if she's not your district judge, you still, but y'all have one of the finest district judges y'all could ever have, and one of the finest people as a district judge that I've ever known. And I will tell you that it is my pleasure to be here today. I'm going to introduce the candidates, basically just tell you their names. There will be allotted time to make opening statements and kind of talk to y'all about themselves and tell y'all about themselves. One of the things, I have been given prepared questions to ask them. There will be no questions from the audience. If they get off topic, I'm going to shut them down. This isn't a time to point fingers and call names or anything like that. I want to know what their answers to these questions are. It's important to me and it's important to y'all. So that being said, I'm going to introduce, over here we have Mr. Spensor, Jim Spensor. In the center we have Miss Amy Bythewood.
Bythewood.
Did I had an L, didn't I? I didn't bring my glasses. I
got some cute ones.
I may borrow them. And Lucas Babin. They have drawn straw. I don't need that right now. They've drawn straws, so there is this particular order that they will proceed. And just so they know that, and I'll turn it over to you, Mr. Spencer. You have 4 minutes.
Jim, would you use it? I will try as long as it doesn't scream all over the place. Let's see how this. Is that okay? Yeah. Too much?
Good.
Okay. First of all, I want to thank everyone who is here today, no matter what candidate you're supporting. The fact that you're here shows you care about your community and you want answers to some of your questions. Secondly, I am so glad that AMB Community Watch is putting this on. When I first decided to run, they were absolutely the first group I went and talked to. So it feels like I'm kind of coming full circle here. My grandfather taught me that Tyler County was where we were from. And it's who we are. My grandfather married my grandmother here in Tyler County in the 40s, and shortly after the wedding they moved to Port Neches, and later down the line they had my mother and my aunt, and of course I came later. But our family always knew that Tyler County is where we come back to. I don't remember a single Christmas, I don't remember a single summer until I was 16 where I was not in Tyler County. And because my parents were young and enjoyed being young, they were more than happy to let my grandparents take me every weekend they were willing to do it. So I spent most of my weekends here in Tyler County also. Just so you know, my name is Jim Spensor. That is not the only name I've ever practiced under. My father has been adopted twice. He was adopted as an infant. He was again adopted when he was, well, I was 32, so he was in his 50s, by a family friend. Shortly after his second adoption, I changed my name too because I just wanted to introduce myself with the same name my parents had. I have a Master's of Business Administration from Lamar University. I got my law degree from St. Mary's College of Law in San Antonio. And I've been a practicing attorney for 28 years in May. When I first started this campaign, it was 26 plus years, but we've been in this campaign for a little over a year now. So I'm coming up on my 28th anniversary. I learned to love criminal law when I was in law school. I had a particularly wonderful criminal law professor, and I discovered that was my calling. So at least 50% of my practice was always criminal law up until the early 2000s. At that time, about 90% of my practice became criminal law because I sold my law office. I moved with my wife and children out to Lumberton, and I started just doing court appointments and hired cases. But basically, just criminal. I did a little bit of family until my wife informed me that the next family case I did would be my own. Those Sunday morning calls do not do good for your marital bliss. As your candidate for district attorney, I've had ample time to talk to the judges, talk to the police officers, and talk to citizens committees. And what I've discovered is that crime is rampant in Tyler County. It's rampant because what's happening is the system is broken. The district attorney's office is giving away things called diversions. That's pretrial diversion. Pretrial diversion is basically 2 years of probation, and if you successfully complete it, you have no conviction on your record, and they dismiss your case. Now, as victims of crime, I don't know how y'all feel about that, but I would not feel very happy about it. If I'm elected your criminal district attorney, I promise to be tough. I can tell you right now, I'm experienced, and I want to see justice done in Tyler County. Thank you.
My turn.
Thank you.
Goody. Now he's spitting. I think y'all can hear me. Back in the back, Jonathan, can you hear me?
Okay. Good evening, y'all. It's good to be here. It's good to be home. This is a courtroom that I've been practicing in for almost 12 years now, and believe it or not, it feels like home. Every little nook and cranny. I came here in 1996. I made this my home in 1996. Don't have any deep roots. Not going to tell you I do. They don't exist. I was born on a naval base. I'm one of those kids. But it was wonderful that moment when we crossed over to Tyler County and I realized that I had a place. I had a place where I was going to raise my children. I was going to a place where I was going to continue to have my marriage. I was going to a place where I was going to live the rest of my life with my family. I was hoping that I would have a law degree one day, but at that time, I had a really hard job, y'all. I was a stay-at-home mom. I had children. I took care of my children. I didn't leave my children with strangers. And when they were old enough to go to school, I went back to University of Houston. And I drove from Woodville to University of Houston for several years. Got my degree, Bachelor of Science degree in political science. And then I went to law school at South Texas College of Law in Houston. During that time, I maintained my relationships with the community. I maintained my relationships with family. Barely. I kept everything going because I was the mom. I was the wife. It's what you do. I successfully graduated from law school by the skin of my teeth, but I got out of there. With being a Girl Scout leader. I got out of there coaching basketball. I got out of there doing what I needed to do to maintain for my family and maintain for my community. And I got to do what I love doing. I got to be a lawyer. When you're a little girl or a little boy, they ask you what you want to do when you grow up. I wanted to be a lawyer. I couldn't explain why at the time, but I can now. I like fairness. I like things done right. I'd like there to be an even say across the board for everyone. I think that that's necessary in our community. And that's the main reason why I'm standing here in front of you today, is because we need fairness. We need something done here. We need something done across the board. It's a nutty concept wanting to run that district attorney's office. I practice here every day. It's a scary place. It's a super scary place. There's some things that there's tremendous problems with. There's also some tremendous successes there, and I don't want to discount the success that we have. We have some phenomenal employees over there who are just going above and beyond to try and keep afloat. You know, we can't discount that. We have some phenomenal law enforcement out there who are doing above and beyond to try and keep things floating. You can't forget that. But we've all got to work together. We're a unit. We're a unit. One of my trainings is in mediation. I like people to get along. If you can't get along, we can settle another way. But I like to try and bring people together. So what I'm doing here is I'm wanting to bring everyone together. Law enforcement, judges, the community.
Finish your statement.
Okay, the community. And that's what I'm asking for today is your vote so I can help bring it together and turn it around. Thank you.
I feel a little like Bob Barker with this microphone here. Can you guys hear me okay? Well, first of all, my name's Lucas Babin. I'm from Woodville, Texas. I work at the Wisenham Law Firm just across the street with my colleague Brad Elrod and my boss Lindsay Wisenham. And I'd like to just say thank you to everybody for being here tonight. I think everybody that's here understands that this is a tremendously important time in our county. Over the last few years, I think it's been 3.5 years or so, we have seen the safety and security of our communities weaken. We've seen our brave law enforcement officers demoralized. We've seen criminals go free. We've seen victims with no justice. And I think it's time to make a change. You all know it's time to make a change. I didn't have to practice law here very long to see that there was a problem that needed to be fixed. And that's not just from my experience with my clients or in the courtroom. It was a topic of conversation just out and about in town. It's something that everybody's been talking about. It's something that my friends, my longtime friends in the law enforcement community talked about. And I thought to myself, why doesn't somebody do something about this? Somebody needs to do something about this. And the more I thought about that, I thought, hey, I am somebody. I can do something about this. I've got the education, I've got the skill, I've got the training, I've got the passion and the energy to make things happen and do something about this. And I'm from here. I care about this place. This is where I grew up. This is where my family lives. This is where I've chosen to raise my kids. And I want this place to be safe and secure for my family, for your family, for everybody's family, for all the families in Tyler County. I didn't move here to run for this office. I came here to practice law and raise my kids here and let them have a childhood like the one that I had. But I recognized that there was something that needed to be changed. And I can tell you, to be perfectly honest with you, politics has never really appealed to me. I've seen a lot of campaigns up close. It's not something that I ever dreamed that I would go into, and it's a sacrifice. It's a sacrifice, I can tell you that. But it's something that needs to be done, and I'm doing this because I care about this place, and I care about your families. And I think I'm the best choice for Tyler County District Attorney because I have a proven track record of success. I've been a lawyer for 3 years, and in those 3 years, I have had about 300 cases. I've been the lead counsel on over 200 of those cases with excellent results. I've won settlements for injured clients, sole managing conservatorship for parents who want a better life for their children. I've had felony cases dismissed. I've achieved not guilty verdicts in felony trials. And I like trying cases. And you'll probably hear more from us tonight or more from me tonight about what it's going to take to make the change that we need. The number one thing is we need to try more cases. We need somebody who loves to try cases. The second reason I believe I'm the best choice is because I'm young, I'm 38, I've got my best work years ahead of me. I've got my whole career. After 2 terms, I'm not even going to be 50 years old. And thirdly, I've been endorsed by the legal community, the people who see me in court all day, every day, not just in Tyler County, but other counties. They know me, they trust me, and they endorse me. And I'm asking for your vote on March 6th. Thank you.
Thank you, Kennedy. I'll ask questions. The same order will apply. Mr. Spencer, on the first question, you will be asked first. The question will be asked of all three. We'll go in order. Mr. Spencer. As a candidate for district attorney, actually, that would be criminal district attorney for Tyler County, what, in your opinion, is the number one priority item to correct if you are elected?
Prosecutions. Right now, after speaking with the judges, we have a lack of prosecutions except at election time. We need to get these people in and get their cases disposed of. We've got a case right now where we've just finished paying for a hospital bed. We've been paying hundreds of dollars a month for someone to be in the hospital because they won't take his case to trial. Now, we need to send a message, secondly, to the criminals. Right now, criminals are expecting to get probation. They're expecting when they come to this county that district attorney, a criminal district attorney, is going to give them deferred adjudication or pretrial diversion or some form of probation. I was told by the Dan B community there's a gentleman running around that has, I think, 54 theft cases pending because every time he bonds out, he goes back and breaks into somebody's house again or steals it out of their yard. This is ridiculous. And that's why I am against more diversions. Until you send a clear message to criminals, this county will not give probations out like Pez candy anymore, and you start sending them to the state to pay for their room and board for about 4 or 5 years, you're going to have this problem. You get some prosecutions down, you get maximum verdicts. You let them know, if you come into this court, we're looking for the maximum. I'm not looking for half of it. You want to waste my time coming to trial in a case that you know you're guilty on? I want the maximum. So you better be sure you've got a good defense if you walk in here with me. At the same time, I can also see where some people may need help, but they can get that help in prison. There are drug treatment programs in jails. There are drug treatment programs in prison. There's one called Safety. In 28 years, I've had 5 success cases of people turning their life around and getting off of drugs. All 5, Safety. One of them is here in this county now. Thank you.
For the same question, do you need to be restated?
Number one priority?
I'm sorry.
That's okay.
We can share. My number one priority would be the prosecution of drug-related crimes. Right now, methamphetamines has become a huge problem in this community. We're learning more and more about that particular drug, and it's very frightening. We're learning that this is a drug that is just coming in contact with somebody's skin can make you positive for it. That's why our children are testing positive for it. That's why babies are testing positive for it. Prosecution of this particular crime is essential to get some things under control. Most of our crimes in this particular county, because this is where I practice, this is the docket that I see. Most of the crimes are related to drugs in one way or another, whether you're buying, selling, stealing, fighting, it's all related. Very few crimes are not related to this drug problem. I'm a firm believer on first-time offenders need treatment. Safety is a wonderful place. It's a probation. You send them there 6 months, halfway house, and they come back within the community in about 9 months to a year. And then they're on probation. If they succeed, they get to live their life. If they don't succeed, they get to go to prison. They get to go to prison. I really, truly believe that if we can get a hold on some of these people, if we can get some type of treatment, some type of help for them, because they all move back here. They all come back. These people don't commit crimes, go to prison, move someplace else. They come back to Tyler County. And so we have a perpetual problem. If we can do something that can get this problem fixed, we have productive members of our society. My number one priority.
Well, the number one priority is to try cases. That's the number one priority. We gotta have somebody that's gonna try cases, and if you're the DA of the county and you're not trying cases, then why are you there? Why are you getting paid? That's what the DA needs to do, and that's what I plan to do. I'm the only candidate that has tried a case in the last, has tried a felony jury trial in the last 5 years. I picked a jury this morning, and the result of that is that will get the docket moving. If there's a threat of trial, there's more incentive for a defendant to plead. If there's no threat of trial, you're going to make an offer to one of the defendant, and he's going to say, well, or what? If I don't take this, or what? What's going to happen? So you've got to create the threat of trial. And the threat of trial is so important that even if you lose a case, you still win in a sense because you've gone to trial and you've shown the defendants that they're going to have to face the music if they don't plea out. Now, my experience with criminal defendants now is that I'll take them an offer and they'll just look at me and tell me to send it back. Like they're at a restaurant ordering food or something. I mean, it's like there's absolutely no fear whatsoever. There's no fear at all. And that has got to change. And I can tell you that I like trying cases. I will try cases. We're going to send the message and set the precedent that if you break the law here, you're going to find yourself in front of the jury if you don't plea out. And I'm going to stick to a one-offer policy as much as I possibly can, with very few exceptions, to also send the message that this is what you're going to get, take it or leave it. And if you don't take it, you're going to trial. And we're going to try as many cases a year as we can.
Second question. Ms. Bythewood, would you support a program for confiscation of property, homes, vehicles, money, etc., from drug dealers to be used to benefit our county? And if so, how does that square with your understanding of due process?
Well, we already have that. It's seizures. You're out there committing crimes, and you're committing crimes in a vehicle using your personal vehicle to do this. Your vehicle gets seized. Your home gets seized. Oh, God forbid your money gets seized. That's the best one. I can't tell you how many people have just magically cashed that paycheck and had $5,000 in their pocket when they got busted for a crime and they wanted their money back. No, that's not how it works. That money gets seized. It goes into the county. The only problem that we have with the vehicles, with the homes, is you've got to have clear title. It's got to be yours. It can't belong to the bank. It's got to be something that the county can take over. You also can't owe back taxes. Believe it or not, people who sell drugs don't pay their taxes, which is a problem that we have. But no, this is a program that's already in place. It's something that can be continued, and it needs to be utilized because this is how our district attorney's office runs. Our district attorney's office gets extra funding from this, as well as their hot check funds. If these things aren't prosecuted, then they, bless their hearts, the people over there lose part of their salaries. They lose part of their salaries. You have somebody who's used to making X amount a year, and if you're not taking care of your seizures or your hot checks, then what happens is they lose part of their salary. Oops, sorry, we can't pay our bills now or our taxes. So I'd like to continue what we're supposed to be doing now and moving forward and following the law. That's why it's here.
Well, the duty of a district attorney is to see that justice is done. And I can tell you that if it's in the interest of justice to take somebody's property, I'm going to take it. I'm going to do everything I can to take it. Now, I don't want to take grandma's house if, grandson is doing something he shouldn't be doing in the room. I don't think that is, one of the bedrooms. I don't think that's in the interest of justice. But if you've got drug dealer driving down the, West Bluff and he gets pulled over, you bet I'm going to do everything I can to take his Cadillac from him.
Well, right now, the law on seizures is it's completely up to the discretion of the criminal district attorney or district attorney, and in a jurisdiction where they do a forfeiture seizure. In our particular county right now, it's come to my attention, we are actually filing forfeitures in this county and then dismissing them when we give them probation. Waste of time and resources to even file it if you know you're going to dismiss it when you give someone probation. I absolutely believe that the way the law is set up right now, since the discretion of the district attorney's office, it has to be done on a case-by-case basis. I've represented people that have had their money seized, and I've represented truck drivers where they had $10,000 in cash. They filed a seizure. No drugs were found, but he had $10,000 cash. He must have been going to buy drugs. So there has to be some discretion there before you seize. But if drugs are found in conjunction with this money, absolutely, we're going to take the money. As far as taking some of the vehicles, the sheriff's office has expressed concerns about the vehicles, that a lot of them are, for lack of a better term, hoopties. And they really don't want to have to be responsible for taking care of a car for months and months and months that's already falling apart and held together with super glue and Band-Aids. I've already spoken with someone over at Woodville High School, and he's in the welding shop, and he is more than willing to take these vehicles over there and let our students use them as training in an auto body program. So there are other ways we can use these forfeited assets to help our community. But as for taking the money, yes, I will take the money, I will take the car, I will take the jewelry, I will take the house. I feel sorry for Grandma. Her son was selling drugs out of the house, but guess who's been paying the bills at that house? Her son selling drugs. And I feel sorry for Grandma, but if she wants to live with her son selling poison to our kids, then she can lose her house. Thank you.
Babin.
Mr. Babin, as you may be aware, the state of Texas has placed burdens on the district attorneys and criminal district attorneys that they must dispose of 90% of their cases every 2 years. Or your county can lose grant money. It can be taken from them if not. How do you plan to increase the number of cases that are tried or otherwise disposed of if you're elected?
By showing up to work. By showing up to work and working all day, every day, like everybody else does, and maybe more than that. I can tell you that I'm going to show up to work, and I'm going to work as hard as I need to work to get the job done. And we can get that number of cases disposed of by trying cases, by just trying more cases. Because if you try cases and you succeed in most of your cases, you're going to plea out more cases. More people are going to want to plea. And you've got to be very, very firm with the people who break the law here in this county. Because what you want to do is send a message that if you want to build a meth lab, and you want to sell drugs, and you want to commit crimes, you're not going to want to come to this county. You're going to sell your drugs in some other county, but you're not going to come here. And it won't take long before we send that message. And I can't reiterate enough. Show up to work hard, try cases.
Basically, that's the right idea, but I think we need a few more specifics to the plan besides just show up every day and work all day. Bottom line is, the criminal district attorney of this county is not a 9-to-5 job. It's however many hours it takes. If you get there at 6 in the morning and you don't drag your butt home till 11 at night, then so be it. That's what the job is. As far as moving the docket, the cases, we only have 2 courts. We only have this courtroom for picking juries twice a month. So it limits you to basically 24 trials a year. You're not going to move over 1,400 cases with new cases coming in every day with 24 trials a year. I've spoken with Judge Blanchett about an idea I have, which is to require the defendants to announce whether they want a bench trial, which means to the judge, or a jury trial to a jury, 2 months before their case is called. This gives us the opportunity to do a bench trial docket. We don't need to pick a jury to do a bench trial docket. All we need is the judges who are available, the prosecutor, and the defense attorney. We can move cases out of the jail. We can put them on that docket. They've announced they want a bench trial. We don't have to pick a jury. So it increases the amount of cases we can do per month. And it goes back to, once you start getting maximum verdicts, you let prisoners know they're not going to be able to avoid going to trial just because their case is number 12 on the docket, so they can buy another 4 or 5 months of time out in the free world. They'll start taking pleas. It's the old schoolyard thing. You go up to the biggest guy in the schoolyard, you pop him in the mouth first day, everybody else leaves you alone. Well, in this case, you go and try the biggest, baddest case you got first, you get a maximum sentence, the rest of them will fall in line. Thank you.
It's okay. I got it. Tyler County is pretty unique. Not only do we have limited trial dates, we have limited judges. We share a judge. We share 2 judges. We share, luckily, we've got Belinda and we've got Earl, and we appreciate them both. But they're housed elsewhere. So we're going to have to look outside the box for some solutions, because that 90% comes from many different ways. It comes from being able to dispose of cases. There are cases that are old, there are cases that are stale, and there are cases that are bad. Those cases need to be dealt with. There are also cases out there that, again, rehabilitation is something that is an option for them, whether it's anger management, whether it's parenting, whether it's a lot of things. That's why I am talking about a diversion program. That's why I am talking about doing something, trying to make the community better within the community. Yes, there are people out there who are bad and need to be punished. I see them every day. I see them every day. But there are more people out there who need to be dealt with in a different manner. We can move these cases off the docket quickly and efficiently by working together. I had the wonderful experience of starting my career with Joe Smith when he was on his game. He would call defense attorneys in his office. We would be called in the carpet once a month for about an hour or 2, and we would work through our cases. I want to go back to that, because without the assistance of your defense attorneys, they're going to circle the wagons. We need to communicate with these folks. We need to communicate that we need a safer place to live for our family. And we need to do that by working together. It's worked in the past. I've seen it. It can work in the future again. It can.
We'll back to,
I think we're over here now,
I was just going to leave it stand up. I don't know. He's the moderator. I'm not arguing.
I'm sorry, I told me I did not see that.
Yeah, this is question number 1. I'm probably going to get in trouble with the damn big bunch, but I'm going to deviate a little bit here. Let me ask you this question, Mr. Spencer. How do you see probation as a tool for the criminal district attorney's office?
Probation, which includes pretrial diversion, deferred adjudicated probation, is a tool in the box. And in a normal situation, I would say you could pretty evenly spread it among the cases. The problem in our county right now is that the criminals have gotten so used to only getting probation offers, or the case stays on the docket so long it gets dismissed, that they've come to expect it. What Mr. Babin said about hearing his criminals say, go back and tell them I'll take so-and-so. I hear that every day too where I practice. I practice in Hardin County, so I don't have conflicts entirely. But I do hear it when I talk to my prisoners in Hardin. Probation can be used as a tool, but on a case-by-case basis. I'm not going to sit here and say I'm going to give a diversion program to all first offenders. Why? Because I've had first offenders that scare the living heck out of me. The scariest kid I ever saw was a 12-year-old who beat a guy to death with a piece of plastic pipe filled with concrete. Had absolutely no remorse. You'd want to offer probation on a first offender. He should never be out in public again. Even though he was a juvenile, he was the scariest individual I've seen in 28 years. Deferred adjudication is my preference if I'm going to go probation, because I can make it 10 years, I can set conditions, and I've already got them basically with 1 foot in the grave. They've already admitted to it. So all I have to do is make a zero tolerance policy on my probation. You do anything outside your probation terms, you're going to come back into court, and I'm going to ask the court for the maximum. That will give them incentive to not break the law again and to follow the conditions of their probation if they want it. Probation is a privilege, not a right.
You know, if y'all are just gonna sit and not all stand at the podium, we could just leave the mic there and everybody can stand at the center. The same question, how would you use probation as a tool if you were elected criminal district attorney in Tyler County?
That's what I would do, is I would use it as a tool. It's an effective tool, but it's just that, as a tool. I don't want anybody to think that I don't like trying cases. I just had my last jury trial a few days before Christmas. So I enjoy trials. Problem here, again, that you've heard is we don't have a whole lot of trial opportunities. Less than 20, good year, pretty much 15. Probation is a tool that we're going to have to use, and it's a tool that we're going to have to use to, first of all, get victims their money back, their property back. It's also a tool that we're going to have to use to be able to keep our probation department afloat. But we're going to have to crack down on people who violate probation. I can't tell you how many people I see fail a drug test and they're on probation. And they're on probation. And they're on probation. And I'm not fussing about the probation department. They can only, as I do this, they can only do what they can do. They need somebody who stands behind them firmly, who's telling somebody, you have these conditions for a reason. And if you can't be in the free world, if you can't be with other people, then you need to go to the place where bad people go. You need to go to prison. We need to have more hearings regarding the revocation process, and we need to have them more frequently. But, it's a tool, and I think it's a very useful tool to be able to try and keep rehabilitation alive. It's also a tool to be able to coax somebody to follow the rules. And if they don't follow the rules, then it's a very simple process to bring them in front of our judge and to have a small hearing and show the judge that they don't like following the rules. And we don't like people living in our community who don't follow the rules. I'll offer my podium.
Well, probation is a tool, and I would offer probation to people only when they deserve it. If they don't deserve probation, they're not going to get it. My job as a DA will be to see that justice is done, and I think we need somebody as a district attorney who's going to be able to evaluate the case, to look at the person's criminal history, to look at the nature of the offense, and in a very calm and manner with reflection to see what the consequences of your decision are going to be, to make that decision and not just rush into it, look at somebody, although some people do need that. Probation there are different types of probation you can give to people. I would use deferred adjudication as a tool. Deferred adjudication is if somebody violates the conditions of their probation and they're subject to the entire punishment range, that's something that you can use to your advantage. And if you know somebody's going to mess up, then you can use that as a tool. And if they do mess up, then you can just hammer them. Because you can file, if somebody's on straight probation, you can file a motion to revoke probation. If they're on deferred, you can file a motion to adjudicate guilt. And the good thing about that is that the standard of proof is much lower. In a criminal trial, the standard of proof is beyond a reasonable doubt. When you go into a motion to revoke hearing, the standard of proof is preponderance of the evidence. So it's just a much lower hurdle to get over. And I would file more motions to revoke probation for sure than we do right now. And I wouldn't just slap people on the wrist. If we've already given them one chance, I'm not going to give them another chance.
I believe we're to you, Ms. Bythewood.
Okay.
I think you kind of answered this, but I'm going to ask this anyway. Not your number one priority, but how would you prioritize prosecutions that you would pursue? Not necessarily what's your number one priority, but of the cases that you got, how would you prioritize what cases you pursue first?
Age. The older a case gets, the harder it is to prosecute. Your victims get older. Your victims move away. Your victims die. Your victims quit caring. The older the case, the harder it is to prosecute. We need to look at chronological order. We need to start getting these older cases moved, gone, out, so we can concentrate on the other cases that we have. Outside of age, we're looking at cases that disturb the community. Cases that truly disturb the community. Things where we have people who are sitting in jail and it's costing this county money. People who are in jail on medical equipment. It costs our county money. There's no reason to leave somebody sitting in jail for several years in a hospital bed. Or leaving somebody in jail and transporting them to Tyler County Hospital 3 times a month, where you have to leave a deputy by their side 24/7. We're wasting our resources, and we are a poor to moderate county. We need to put our resources to work for us better and not waste them. We don't have excesses here. So to answer that, I would start with the older cases, see what can be done with those. And then I would start looking at the disturbing cases, our murders, our rapes, our child victims. Let's start moving those. As much as I hate for somebody to write a hot check, I can deal with that for a little bit longer than I can for a child to write a letter to my district judge telling my district judge, dismiss this case. There's no justice in Tyler County for me. I don't even want to prosecute anymore.
Well, I would also say the age of the case and the nature of the offense. The age of the case, because of statute of limitations issues, you can't let a statute run on an offense and then you can't prosecute. Secondly, because of, just like Ms. Bythewood said, witnesses forget things, facts go away, evidence disappears. If you let something sit too long and collect dust, it's going to be much more difficult to prosecute. I can give you an example of that in my own practice right here in this courtroom. I had a case that was set for trial several months ago, and it had been set for trial several times. The case was 6.5 years old. Just a few days before we were supposed to start picking a jury, the case was dismissed by the DA's office. And the reason it was dismissed is because the key witness, they discovered that the testimony was not going to be favorable to them, and it would not have been in the interest of justice to pursue that case. And while it's great that they figured that out, you've got an injustice either way there. If the guy was guilty, and he really did it, you've got a guilty guy out there because maybe that witness just forgot the facts because it'd been 6.5 years. On the other side, if he was an innocent guy, he had a felony hanging over his head for 6.5 years, and you can't do that to somebody. So I would say, there's no telling how many cases there are like that over there that I'm going to have to call through and just, take a look at the probable cause affidavit or the offense report and see and who the witnesses would be, call them and figure out if it's a good case or a bad case. And if I'd start with the very, very old ones. And secondly, the nature of the offense. I mean, clearly if you've got some egregious offense and somebody that needs to be gotten rid of very, very quickly, he would be a priority.
Thank you. Well, first let me say, the criminal district attorney's office they can prioritize their resources, but they aren't the ones that decide the docket. The judges decide their dockets. They'll tell you what case is number 1, number 2, number 3. As an attorney found out in Judge Stover's court not that long ago. But as far as prioritizing my cases, I think we need to prioritize, first of all, age. Secondly, incarceration. If we are paying to have these people sitting in jail, and by the way, we're paying to have prisoners in 3 different counties right now because our jail is so full. So we're paying your tax dollars to house people in other counties. We need to move those cases. Also, we need to look at, as Ms. Bythewood pointed out, the heinousness of the cases. There are some cases that have been here for so long. 5-year-old sexual assault cases of a child. These victims can't heal while their perpetrators are still out there waiting to go to trial. So it's going to be a delicate balancing act, and I think we cannot just make a blanket statement, I'm going to do all the jail cases, or I'm going to do all the older cases. I think the district attorney is going to, or the criminal attorney is going to have to go in and look at each one of these cases, case by case, and decide what needs to go. And then talk to the judges. Since they set the docket, we can tell them, Your Honor, we'd like this case set number 1. You decide that, but we're requesting that, and this is why. Thank you.
All right, Mr. Babin, I believe we're at the 6th question, so you'll be next. It's actually 7 now, so there's going to be one additional question. Aside from body cams that hopefully all of your officers are now equipped with, why is it necessary to videotape criminal behavior such as drug deals to prosecute the case?
Well, I can tell you there's not any such policy that requires videotaped evidence. The duty of a DA is simply to take a look at the facts of the case and see if you can prove every element of the offense beyond a reasonable doubt. If you can do that without videotape, great. If you can do that with videotape and you've got the videotape, then even better. But the bottom line is, I'm going to take a case that comes in, I'm going to take a look at it, and if I think we can succeed and get a conviction on that case with no videotape, then great. If we have it, even better. And I think we should try to get videotaped in every case that we can, but it's not an absolute necessity.
Mr. Spencer?
Actually, it is unwritten policy here. Several years ago, Deputy May Shaw did a bust in a drug house. He brought that case to JoJo. JoJo refused to take it because he didn't have a video. Since then, many of you have asked me, why aren't they busting these meth houses? That's why. If you can come up with a better answer, come tell me. I was surprised when I first heard this from one of our constables. I thought he was kidding me. I couldn't believe it. I've since talked to several law enforcement and found out, nope, it's true. It's an unofficial policy. When JoJo refused that the first time, they quit trying. Now, do you need video in a drug bust? As a prosecutor, I would love video in a drug bust. A picture is worth 1,000 words. But I've worked in cases where all they have is the affidavit of the officer, marked $20 bills. You got your bust. You go in after the officer's done the buy and you bust the place with a warrant. You find your $20 bills that are marked. Case done. So I don't believe you need video. Audio tape would be nice, videotape would be nice, but it's completely unnecessary. If you're telling your officers, we're not going to accept your case without video and audio, you're telling your officers, I don't trust you. I don't trust your word. And when you get in here and put them on the stand, you think a defense attorney isn't going to use that? Your own prosecutor doesn't trust your officers. Why should you? No. Our officers are out there putting their butts on the line every single day. Every day they walk out of that house, their wives and children don't know if they're going to come back that night. We trust them. If we trust them, then we believe what they say. And that's good enough if they give me an affidavit. I'll prosecute on it.
Thank you. Ms. Bythewood?
One more time on the question.
The question was, aside from body cams that all officers wear, why is it necessary to videotape criminal behavior such as drug deals to prosecute the case?
And the clear answer is it's not. I practiced criminal law here for 11 years, and that's not a policy that has been across the board. I've had several cases. I've had many cases where there was an affidavit, where there was some money, where there wasn't any videotape. I can tell you that there are instances where something's taken to a grand jury and the grand jury rejects it because they want videotape. I don't know if they watched CSI the night before or whatever, but that is something that happens as a grand jury can kick a case out. The other issue, and this is the only officer name that I'm going to say in this context, is Gary Parks. If he had brought a case to this court with videotape, it would have been rejected. I mean, unfortunately, there have been some officers that are no longer officers in this county whose credibility is not very good. That's why they're not officers here any longer. But it's my understanding that that was a problem that was had at one time. But as for that being a policy here, I can tell you that that's not true because I've had cases where we've had affidavits and we've had money. I can tell you I like videotape. Everybody's got body cams. The defense attorney is going to tear somebody up because you're not utilizing the resources that you have. I've also had cases where someone was misidentified. Very close-looking individual, but he just didn't happen to have that particular tattoo. And the case was dismissed again. And that came because of a dollar store videotape. But, yes, I would love to have the perfect evidence in front of me to try a case. But having a good officer's word, having a good officer's case, that's good enough for me.
Mr. Babin, I'm going to continue this question. So it's going to be your turn again. I've got a follow-up question that's in relation to that. So this also has to do with videotape. I want to give you a different circumstance because that was a very general thing asking if it's necessary to videotape. In a situation, say, where your law enforcement sends in a confidential informant, a non-law enforcement agency, why is it necessary to have a non-law enforcement officer to go in and make a drug buy? Why is it necessary in those instances to have videotape? Do you understand my follow-up?
If you can repeat that.
Okay. I'm giving you a specific type of case where law enforcement uses a confidential informant, someone that's not law enforcement, to go in and make a drug buy. Why is it required to have videotape in that instance?
Well, in that instance, first of all, you got a confidential informant. You don't want to have the identity of the informant disclosed. And if you have videotape in that situation, then I would have to know more facts about a particular situation and a particular case. I can tell you that I have cases right now where it was a confidential informant, and there's no videotape of that. I have to have more facts, and I'd have to see the actual case, as opposed to just a hypothetical question.
Okay, thank you. Mr. Spencer, same hypothetical.
Well, in most cases when they use a confidential informant, this is not a fine upstanding citizen who's decided to help law enforcement. They've been busted, and they're trying to cut a deal. And normally the deal is, you give us 3 busts, and we'll talk to the DA about your case and ask for a better deal. Or you give us 10 busts, and we'll talk to the DA and give you a better deal. So there's always some suspicion on this confidential informant that he might be using some sort of entrapment. Now, I'd rather take this on a case-by-case basis with informants. And Ms. Babin, they can discover who the informant is, and especially if you've got a videotape, most of them will realize exactly who was there when they bought it. So they're going to figure out who the informant is. I would prefer to have a videotape with a confidential informant simply to remove that defense from a defense attorney. That, oh, you entrapped my client. But unfortunately, you may not be able to do that. Drug dealers are becoming more sophisticated, and they know to look for these little cams, especially since they've gotten so small you can put them in a pair of glasses or in a tie clip or just a pin on your hat. I can't say one way or the other whether I would take the case or not. I would have to look at the informant. Normally these informants have certain requirements before you can even get a warrant for them. They have to have worked with officers and been proven as to their veracity 2 or 3 times in the past. That has to be included in the probable cause affidavit for any warrant that's issued. A lot of times, I've run into this in Jefferson County where officers would use a confidential informant one time and say, oh, they're reliable. And then when the defense attorney starts looking, he finds out, yeah, it's the first time you used them, how do you know they're reliable? And your case falls through. So on a case-by-case basis, I would have to look at it. I would prefer to have videotape with an informant, but that's not always what's going to happen.
Thank you.
Lack of credibility. Plus, I'm just somewhat offended that this guy's going to get off because he can rat on his friends. You know, that just kind of bothers me. And that happens a lot, where you have someone who's busted, and if they do bring in some other bust, then that's taken into consideration, and that bothers me. Because they were out there doing something wrong. And I don't like the idea of anybody getting off scot-free for doing the same thing everybody else was doing. It's not fair, going back to the F word, fair. I think that we need to hold these people to be much more accountable. And I'm talking about the little drug dealers, you know, the little fishes. We work on our little fish, our medium-sized fish. The big fish just kind of slide through town and we never see them, if they even come through. But it's the lack of credibility to go to answer the question. You have someone who's doing drugs, who's been using drugs, who's known in the community as a drug user, as a thief. There's not a whole lot of credibility that they're going to be giving on the stand trying to testify about something as to the veracity of it or not. They committed 10 million crimes of moral turpitude. They're, in the famous words of Gary Butler, they're convicted liars, and I wouldn't feel comfortable with that without being more involved with that particular case, which is where the DA's office and the sheriff's department, the police department, the constables need to be working together more. Need to be meeting together more. It's not this entity and this entity and this entity. It's an us situation. And we've got to work together to fix this. Not separately, not autonomously, together.
All right. Last general question, Mr. Spencer. Mr. Spencer, what is the most significant felony jury trial you have tried in the last 5 years? Yes, I'm sorry.
Well, because of my experience, I haven't had to try a jury trial the last 5 years. The 4 trials that I've been called to trial in the last 5 years, one was a case where my defendant was accused of robbing a convenience store of a keychain and some beer and cigars. I informed the district attorney that my client was actually the victim, not the defendant. There were about 45 minutes of videotape. I looked at it until I found 3 scenes when I slowed it down to clips, and it clearly shows the clerk of the convenience store stealing $300 out of my client's hand that he was holding. And then when my client tried to retrieve his money, the clerk hit him with a bat, chased him out of the store, and reported it as a crime. I decided to take this one to trial. On the day of trial, the district attorney suddenly had a change of heart and decided to dismiss the case. On the other case, I was taking the trial. On the day of trial, let me go back. My client was looking at what we call a bitch, which means habitual. He's had 3 prior felonies. He's looking at 5 It's for habitual. It means he's looking at 25 to 99 years or life in prison. What I discovered is that the officer in his report had said he had a malfunctioning video camera in the high-speed chase. He was evading with a motor vehicle. I simply requested that the district attorney's office provide me with a copy of the work order he turned in to fix the camera in his patrol vehicle. I was later informed, well, it didn't exactly malfunction. I didn't know how to operate it. Ladies and gentlemen, that is a felony when an officer falsifies his report. The officer no longer worked in Hardin County and had moved to Jefferson County, so I filed a motion to depose the officer. After fighting my motion for 4 months, the district attorney decided to offer 2 years deferred adjudicating probation because my client had given a confession in the back of the car.
Yeah. The last case that I had in front of the judge, and it was not a jury trial. It was within the last 5 years, and this was it was an open plea. My guy, he was a really bad boy over the course of the weekend, and the district attorney's office agreed to dismiss the DWI charge and go forward with the possession of PCP charge. And I thought that that was a very good opportunity for us to go in front of the judge and ask for probation, even though he wasn't eligible from a jury, he was eligible from a judge. And there's different standards. Once somebody's been to prison, a jury can't give them probation, but a judge can. And I thought, hey, let's use this opportunity to see if I can make an argument for him to go to some type of drug treatment. We had our argument, we went back and forth, and I don't consider it a total loss. She gave you 7 years, not 9 years, and he's out. He's out. But this happened about 2.5 years ago. 7 years, 2.5 years in prison. Before that, my last trial, and I'm going to tell you straight, I've had about 12 jury trials, civil cases. I like juries. I like getting in front of juries. I understand juries. I like talking. But the one prior to that was a bench trial, and my client was a kid acquitted after he had a heart attack and died right there. Yeah. That was on September 11th. But anyhow, that's what's been going on in my criminal courtroom experience here off the last couple of years.
Right, sir.
Well, as I said earlier, I've been practicing law about 3 years, and in that time, just in the last 6 months, I've had 7 jury trials set, number 1 on the criminal dockets in this county and other counties. 6 of those were felonies, and I've had 2 felony jury trials in that amount of time. I picked a jury this morning. I had a felony jury trial several months ago, last fall, which I won. We got a not guilty verdict on that. I like to try cases. I think my record shows that I try cases, and I'm going to try cases as DA.
All right. Ladies and gentlemen, I have 3 more questions. These questions were actually taken from each of y'all's published platforms that y'all ran in the Tyler County Booster. So I'm going to start. I'm going to ask the person who stated this information or that this question came from, and then I'll allow the other 2 to respond to that also, and then we'll go so forth. And I'm going to continue in the order that we have. So, Mr. Spencer, you will be first. You stated that one problem you would change is that when officers, deputies, law enforcement personnel pull someone over for suspected DUI, that the officer must call in a DPS officer that is certified to administer a sobriety test causing delays. Could you be more specific about that process?
Yes, this was brought to my attention by Constable Zachary. I also talked with Stephen Sturrock, who verified it. I spoke with Rossi Caruth, who also verified it, and we spoke with Chief Yosco, or I had an intermediary speak with Chief Yosco less than 2 days ago, and he verified that is the procedure. For some reason, JoJo, our former district attorney, refused to allow officers to do field tests. Now, this doesn't mean DWIs in general. This means the field test. When you go out, hold one leg up, do the pen in front of your eyes. They're only allowing DPS to do these field tests. If DPS is not available, then they either have to wait on the side of the road for DPS to show up, or if the person will agree to do a breath test or a blood test, they can go that route, which costs us money to do those, and it also costs time. What I would suggest is, and I've already talked to Stephen about it, is I would like to see the officers start becoming certified again. We have a few officers who are certified to give these tests, but not all of our officers. It includes constables, sheriff's office, and Woodville PD. We can slowly do it. It's not that expensive. We have plenty of time until the next district attorney takes office. And once the officers are certified, they don't have to wait for someone else to do the field test. They can do the field test. It makes our officers more efficient. People who live in Woodville have 4 or 5 officers who are on duty at any one time. The rest of the county has 2 sheriff's deputies for the entire county at any one time. That means if the sheriff's deputy is in Chester and he gets a call down in Fred, he's 45 minutes away. The rest of our county is dying because they're losing time traveling. So let's make our sheriff's officers more efficient by allowing them to do these field sobriety tests when they come across someone who is obviously intoxicated. Thank you.
We'll stop when we like to respond to that or discuss that also.
And that's the DWI?
Yes, and the ability of officers, deputies, law enforcement personnel other than DPS and their ability to do field sobriety tests.
I don't care who does a field sobriety test. My understanding is that this is an agreement between the law enforcement, that is not a mandate from the district attorney's office. That kind of confuses me, since I've seen cases that don't have a DPS officer involved with them with the field sobriety test, as long as the person who's doing it is certified to do it. Problem is again, low to moderate income area. We do not have the funding to send the officers off to get certified. We don't have that. If it's there, use it. Absolutely. Let everybody be certified. I don't have a problem with it. I think that as much cross-certification out there that can be done is a good thing within law enforcement. I just want to know who's going to pay for it. Because I know you talk about raising taxes by 20 cents and people go nuts. That's an issue, is how are we going to pay for these? Now, if there's grant programs available, that's fantastic, but that's a law enforcement issue in getting them certified, not the DA's office to get them certified. It's my understanding, but as for there being something implemented from the district attorney's office, again, my criminal practice, and I still have about 40 cases. I got off the appointment list and I quit taking new clients on about a year ago when I started this journey. So my criminal practice has dwindled down over the last year or so, just so that I wouldn't have issues with conflicts. But I've not had that problem. In fact, I'm fighting with them right now on one where we didn't have a DPS officer there. And they're not buying my argument that we should have had a DPS officer there. But I don't have a problem with anybody being trained. That's a good thing. My problem is how you going to pay for it? And saying that it's mandated from one office to another. I've never seen that work in this county or any other county where you have the district attorney's office telling the sheriff what he's going to do or what he's not going to do. That just doesn't happen in my world.
Yeah, any of our officers can do a field sobriety test. Our sheriff's deputies, our local PD, the DPS officers are the only ones that are trained to do the breathalyzer test. And I've spoken to many of our law enforcement officers in all our different agencies, guys that I've known for almost 40 years that I grew up with. Occasionally what they'll do is, if there's a DPS guy available, they'll call him in and let him do the breathalyzer, because DPS is required to get a certain number of DWIs a year. And if they're available, and they can come do the breathalyzer, then there's a courtesy they let them do that. But any law enforcement officer can do a field sobriety test right in front of the dash cam video and get a conviction on a DWI.
Ms. Fox,
Yes.
you stated that you would continue to improve and establish innovative diversion programs.
Yes.
Could you explain what you mean by innovative diversion, and under what circumstances would you use that?
I'm going to use Mr. Babin over here as an example. He had a client recently, and I know this man personally, who spanked his child for attempting to burn down the kitchen. He overspanked the child, and this person had a significant criminal history. But was it an overspanking? Yes. Was it something that he needed possibly anger management, some parenting, some type of other training for? Absolutely. Instead of wasting taxpayer money and going through an entire trial, bringing people up here for several days, that case should have been placed in a diversion program. A convicted felon placed in a diversion program. CPS came out, let the kid in the home. Let the kid in the home. You know? So what are we doing? Taking the guy out of the home who has turned his life around and sending him back to prison because he spanked his kid for trying to burn down the kitchen? No, we need to give him parenting. Those are the type of programs that I'm talking about. Those are the type of issues that we're facing, is we have some folks out there who need some good old-fashioned parenting, good old-fashioned anger management, those type of programs that do not cost this community a whole lot of money, but can give the community so much back in return. That's what I'm talking about, thinking outside the box. I'm not looking at somebody who keeps doing a DWI and saying, just give him another diversion. I don't even believe doing a pretrial diversion for somebody on his first DWI across the board. I think that needs to be revamped and looked at. But we have a lot of different issues going on in this office with defendants that can be taken care of in a different way. We need to be communicating more with law enforcement. We need to be communicating more with our judges to see if we can come up with an idea that doesn't waste taxpayer time, jury time, court time, and the money that goes to be involved with that. We also need to send a message to people that when they come to jury duty, something's going to happen, as opposed to just having 53 people show up and have a judge fuss at them a little bit. Well, thank them a little bit. But it's getting ridiculous. We're talking about sending a message to the criminals. We need to send a message to our community that when you come here, something's going to happen. You know, you're not coming here for nothing. That you're not just sitting there giving your $7 or $9 or whatever to the Child Welfare Board. You could give them a $10 bill and not come. That would be fantastic. That's what I'm talking about with the diversion program, not being light on crime, but looking at each individual offense and seeing what can be done to dispose of it so we can hit our 90% or more. So we don't lose our grant money here and in the Sheriff's Department and throughout the rest of the county.
Mr. Babin, would you like to discuss diversion issues or some type of innovative diversion programs?
Well, I will say that, sure, there are cases where pretrial diversion would be in the interest of justice, and you don't want to just ruin somebody's life with a felony. If you check out the nature of the offense and look at their criminal history, and there are times when that may be appropriate. But I can tell you from firsthand experience that most of the people in our justice system here, these are people that are the frequent flyers. These are people that are recidivists. You see them all the time, same names, same faces. Most of these people are not good candidates for that. A lot of these people just, quite frankly, need to be hammered and need to be sent out of here. When it's appropriate, sure, I'll consider that. But it's going to be an exception, not a rule.
Thank you. Mr. Spensor.
In Texas, there are several different kinds of diversion programs. Basically, what diversion means is you serve a probation term, there's no permanent record, so no conviction, and the case is dismissed. Pretrial diversion, maximum amount of time you got, 2 years. The only time I would consider pretrial diversion is a case where the defendant really didn't break the law, but still did. For instance, you've got 4 friends that go out one night. 3 of them decide, hey, let's go vandalize so-and-so's house. The 4th one says, I don't want any part of this. Take me home. We're not taking you home. You can walk. It's only 3 miles. Or you can sit in the car. Okay, I'll sit in the car while I'll vandalize the house. But then he doesn't report it to the police. Technically, he's part of that crime. But he didn't really participate. I could see pretrial diversion for that person. Other than that, the only pretrial diversion program I would even consider is deferred adjudication. You can do 10 years. You can set conditions, and they've already pled guilty. They can't come back and say, I didn't do that. No. When they go back into court, all you have to show is they violated any term and condition of their probation, except not paying fines and fees, because Texas is a debtor state. But if you show they missed 1 probation meeting, they didn't take the class, they didn't do their community service, they didn't go to the other classes they were supposed to go to, they didn't stay away from someone they were supposed to stay away from. All you have to do is tell the judge, Your Honor, they violated their probation. I want you to sentence them to the maximum. I was told when I clerked at the Jefferson County District Attorney's Office by Craig Miller, my supervising attorney, the best way to put a criminal into prison when you're not really sure you can make the case is give them deferred adjudication in about 30 days. They're going to screw up, they're going to be back in court, and then they're going to be in prison. Thank you.
Last question, Mr. Babin. You'll start this one. You stated that if you were elected, you would eliminate last-minute plea deals. Explain why plea deals are made at the last minute and what steps you would take to stop future last-minute pleas.
Well, last-minute plea deals are a way that you can avoid going to trial. And that's happened to me several times. We'll negotiate back and forth multiple times for months and months and months and up to a year or more. And we'll have numerous plea offers, numerous. I've had cases where I've had 4 or 5 different plea offers. And if you send jury summons out, and if the county is paying, if you've got an indigent defendant and the county is paying for that, the client or the attorney to represent that defendant, he does all this work, he writes his opening statements, he prepares his evidence and gets ready for trial. We spend the money to send out the jury summons, and then at the last minute, we plea him out. Now, the downside of that, in my opinion, primarily is that what kind of message does that send to defendants? They can hold out until the very last minute, and they know that they can plea out right before they have to face the music. In my opinion, that is a very, very bad policy to have. I've spoken to people who have been district attorneys for many, many years, and they've told me that they have a one-offer policy. And I would stick to a one-offer policy as best I possibly could with very, very few exceptions. I'd take a look at the case file, and I would think, this is probably what a jury is going to give this guy, so I'm going to offer him a little bit less. And I'd make that offer to him, and if he doesn't take it, he's going to have to go to a jury trial. And I'm not going to plea him out at the last minute, because that is going to set the precedent that that is not going to happen anymore. And when you send that message, you're going to get more pleas. You inevitably will get more pleas. So that is going to achieve the objective of getting the docket moving, and that's exactly what we need to do.
I also have dealt with last-minute pleas. In fact, the last 4 trial cases I've had have either been dismissed or they've gotten a sweetheart deal at the last minute because the district attorney doesn't want to go to trial. That having been said, last-minute plea deals are part of the tools in the box for a prosecutor. We don't like them, but my policy would be, if you want to deter last-minute plea deals, never back down from your last offer. I offered you 12 months for a misdemeanor. You didn't want it. Well, I want a plea now. Fine, 18 months. Or go to trial. As long as you don't back off your offer, it does offer incentive for them not to wait till the last minute. But there are other considerations here. What happens if you as the prosecutor know that one of your witnesses is shaky? They may not want to take the stand. And you're looking at the possibility of either a plea deal at the last minute or a dismissal of somebody who really does need to be punished. That comes into factor in also. Now, do you want to waste one day bringing a jury up? And by the way, it's not a waste. Or do you want to force them to go to trial and waste someone's 3 days in trial on a case that could have been pled out? The bottom line here is, it is part of the toolbox. It would be used sparingly and only in select situations, but I would not totally discount taking a last-minute plea deal so long as it never goes below what my last deal was. Thank you.
It's fine.
It's something that I would work on a case-by-case basis. Another consideration for someone pleading versus someone going to trial is the right of appeal. When someone pleads out, they waive their right of appeal. They waive their right to a new trial. And that's another financial consideration to have for this county and for the taxpayers. Weighing out in the interest of justice. It's got to be by a case-by-case basis. I would not eliminate last-minute pleas. It would be something that would be a consideration. It absolutely would. When you're looking at different periods of time in prison, that's probably when it would come to play more. What's the difference between 7 years and 5 years to us? Oh, it's 2. We do the math. Well, there's new math involved. I asked my first question, are we going to have to do math? I'm putting math out there. There's not a big difference in prison, depending on the crime. I mean, if it's a 3G crime that's aggravated or it's violent, yes. But for the most part, there's not a big difference between 7 and 5, you know? And you're getting the person off the street. And they don't have a right of appeal. And they don't have a right to new trial. And you get to look at the jury and say, look what you guys did. This person came in here, saw the conservative, good people at Tyler County, and with fear in their heart said, please let me go to prison for this amount of time. You know? It's a tool. It's one that I've seen used very effectively, and it's one that I've seen used very ineffectively. But it's got to be used on a case-by-case basis. It can't be discarded completely, can't be totally eliminated, and it can't be allowed each and every time. You can't have somebody come in, and I've had this experience with a district attorney, who's not in this room, where I knew that if I just pushed it for a jury trial, I could go in and get a great deal, even if they had a great case. And we'd go, there'd be a jury, I'd give me a good deal, and we'd walk away. That can't happen here. That's not a good message. But again, you've got to weigh what's in the interest of justice.
Thank you, candidates. That concludes all the questions that have been prepared for y'all, along with some additional 2 that I came up with. Each candidate now will be allowed 4 minutes to make closing statements, and we'll go in the same order as the straws y'all draw. So, Mr. Spencer, you'll be first. You have 4 minutes.
Thank you. One of the questions that was asked is how many trials have you had in the last 5 years? Well, I've been practicing 28 years, as opposed to the 3 and 11 of my opponents in this race. After 28 years, the district attorneys I deal with know if I'm going to trial, I've got a case. I don't go to trial if I don't have a case. I don't try cases just for my ego or because I want to notch up trials on my belt. A defense attorney's outlook on cases are completely different than a prosecutor's. A defense attorney only goes to trial if he can't get a decent plea bargain or can't get a dismissal. A prosecutor has a completely different outlook. They always go to trial unless the defendant decides to take a plea bargain or they find sufficient facts to request a dismissal on the case. Given those 2 outlooks, what I'd like y'all to understand about me is I will use all the tools in the box. But with the crime rate we have in our county, when we have people who have 54 theft cases who are still out walking around among us, the time to use diversions and be soft on crime has passed. It's time to be hard, at least for a while, until the criminals understand they're not entitled to probation anymore. They're entitled to go to TDC. As far as saving money, you want to save money? Revoke their probation and send them to TDC. You know who pays for that? The citizens of Tyler County? No, the state. And they're out of our ear for a few years, at least. Drugs are the basis of the problems in our county. I've had opportunities to talk to my clients who are drug dealers. Bottom line, drug dealers look at it as a business. That's how they put clothes on their kids' backs. That's how they put food on the table. If you make business bad in Tyler County for drug dealers, you can't get rid of it, but you can make them go somewhere else. And that's what we really need. We need them out of our county. If I'm elected criminal district attorney, what I can promise you is this. The first thing I will do when I take office is revoke every plea bargain offer that's been made. So, to defense attorneys out there, if I am elected, you've got till the first of the year to get your cases pled out or be prepared to start going to trial. Now, can we go to trial in every case, as Mr. Babin would like to do? Unfortunately, no, we can't. We have limited resources and a limited number of trial dates per year. So you have to vote. Did they go to all their community service? Did they go to all their meetings? Did they go to their classes? Have they been following the rules? Oops, he missed one rule. He's not paying. Guess what? Judge Gibbs, I'd like to have this person revoked, and I'd like you to give them the maximum. Here's their criminal record. That's what I promise to do as your next criminal district attorney, is to look at our budget, to look at our situation, to take them on a case-by-case basis, and start moving the numbers and getting our crime rate down and getting the criminals out of Tyler County. Thank you.
Thank y'all for coming out and listening to us. I appreciate that. I honestly would rather have been at home on the couch like many of y'all, but this is important. This is a very important race. And I'm part of this race because I love this county and I love the law. And I'm concerned about this county and I'm concerned about the law. Unlike someone alluded to, I am not soft on crime. I'm trying to find a solution. I'm trying to find a workable solution for the folks in Tyler County to sleep better at night with their locked doors, but still sleep better at night. What I'm trying to do is trying to find a solution for people who have done something stupid. Yes, it's a crime, and fix it. Fix it. Then we don't have the problem again. If we can't fix it, then what we have to do is we have to put some folks in prison. I want to utilize every court date that's available to us to have trials. That's very important. I want to work with the judges on the docket so that we can have the hit list, so that we can have the top 5, the top 6 charges on there and do something with them, and not just have a perpetual list of people coming in after month after month. Hey, how you doing? Yeah, there you are. Wow, your hair got grayer. I mean, we don't need to do this anymore. Cases are moving. Don't think they're not, they are. We have cases moving here, but we need to have more cases moving. We need to have those old cases gone. We need to have those cases that are sitting in my file cabinet that have been completely forgotten about, dealt with, because I'm not the only attorney that has them. Not the only one. We need to be able to move on with a clean slate as quickly as possible. Let me tell you, that quickly as possible will be in term 2, because we got a mess. But we also need to have somebody, and this is why I'm standing here, somebody who can work within the system that we have. Someone who has an established relationship with our judges, with law enforcement, with the community, with the defense attorneys, with everyone who's involved with this mess, so that we can clean it up together. Because this is not a DA problem, and it's not a sheriff's department problem, and it's not a county court problem or a district court problem. This is just a problem that we all have to work together in dealing with. I've been here when it worked. I want to bring that back. I also want to get rid of some of the stuff that's not working. There's a word that's in everything that I put out there. That word is every day. That word is not a slight towards the current district attorney. That word was inspired by Ben. Because when he first ran for mayor, he wanted to be the best he could be every day. I want to be the best I can be for you every day. I get phone calls at 11 o'clock on a Saturday night that I have to ignore and then call back. It's what I do. It's what I do now. I have to watch guard house videos where 3-year-olds tell the camera what their daddy did to them. I have to look at videos and photographs of murders. I do this every day. And I'm willing to continue doing that for this county every day. I have a passion, I have a responsibility, and I have a love to continue this for this county, because only a crazy person wants to go in that office. Trust me on that. It's a mess. It's someone who has a passion and a love and a commitment. I've shown you my commitment to this county for the last 22 years and in this profession for the last 12. I'm asking that you allow me to continue that commitment to you as your next district attorney for the next 60? I was trying to come up with my number. I'm here for the long haul, y'all. Thank you.
Right. Well, I want to thank everybody for being here tonight. Thank you very much. And listen, let me just tell you that campaigns are about words, and being a district attorney is about work. My track record speaks for itself. I've been an attorney 3 years, and I'll stack my experience up any day with my opponents. I cannot ever imagine a time, as long as I'm doing criminal law, as a defense attorney or a prosecutor, when I would ever go nearly 20 years without doing a felony jury trial. I can't imagine ever doing that in my career. I'm going to try cases. My record shows that I'm going to try cases. I've got a track record of success as an attorney and before I was an attorney. Before I was an attorney, I had the good fortune of working for some of the biggest movie studios in Hollywood. I was in some of the biggest ads around the world for some of the biggest brands in the world. I was the only American to be on a South American primetime television show. I did almost 100 episodes of that, and I had to learn the language of Portuguese to do that. Whatever I need to learn, I'm going to learn it to achieve the objective. I'm going to support law enforcement. I'm going to make it a team effort. We have some very, very fine men and women in our law enforcement agencies that are very capable, highly capable. We need to come together as a team, and in my opinion, we can all win together, or we can all lose. It's my goal to be the most accessible district attorney that we've ever had. I want the law enforcement to be able to call me anytime they want. And if I don't answer the phone, they'll know that I'm going to call them right back. I'm not going to dismiss a case unless I let them know about it. I'm going to have the courtesy to do that. And I'm going to bring us together as a team, and we're going to work together. I'm from Tyler County. I love Tyler County. This is where I'm raising my kids. There are many places I could have gone, but I wanted to come right here because this is where I'm from. This is where I want my kids to grow up. And I want to do everything I can to make this county and our communities safe and secure for my family, for your family, and for all the families of Tyler County. Thank you for being here. And I would ask for your vote on March 6th. Thank you.
Ladies and gentlemen, thank you all. That ends the time. Thank our candidates. Thank the Danby Community Watch for having us here.